Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Today, March 3rd, 2026, was the first time in approximately 7 years that the United States Supreme Court entertained a case on a petition for writ of certiorari dealing with criminal appellate waivers, situations where a defendant who has been charged with a crime agrees to enter into a plea deal with the government in exchange for some sort of concession. It could be for less time than what the crime charged could potentially cause that defendant to serve if he or she was found guilty following trial. It could be, as in the case of Idaho versus Kohberger, an agreement of the state of Idaho to take the ultimate, the DP, off the table in what was a capital case. The last time the Supreme Court entertained a matter dealing with appeal waivers happened in Garza versus Idaho. That's a 2019 SCOTUS case. These appeal waivers, for all intents and purposes, mean that the defendant will not have an opportunity to have the sentence reviewed by any higher court, save one or two reasons. Hunter was seeking to expand the possible grounds for appellate review when a general appeal waiver has been negotiated and signed. The two principal issues before the Supreme Court today were, number one, whether the only permissible exceptions to general appeal waivers are for claims of ineffective assistance of counsel, or that the sentence exceeds the statutory maximum, and two, whether an appeal waiver applies when the sentencing judge advises the defendant that he has a right to appeal and the government does not object. Oral argument today in Washington, D.C. at the Supreme Court commenced shortly after 10 a.m. when the Chief Justice of SCOTUS, John Roberts, called the matter. You can listen to repeat of the live audio that was transmitted. I've provided a link to the Supreme Court website. Because it was Mr. Hunter who was bringing the petition, his attorney spoke first and went over various grounds and various reasons why the basis for overriding an appeal waiver was proper, beginning with contract law. The matter was only supposed to go for an hour. It went much longer than that, suggesting that the court was very interested, had a lot of questions of both sides, a lot to think about, and a lot to consider. The big issue is, when will the Supreme Court's ruling come down? That could potentially change the national policy uniformly on the issue of appellate waivers. At this time, an opinion, a vote is pending. That opinion is scheduled to be published on or before the end of June of 2026, because the end of June is when the Supreme Court closes down shop, if you will, and returns in October. We are going to monitor the docket for that opinion, and once SCOTUS issues it, we will, of course, advise you. So please stay tuned. Until next time, this is Kathy. Thank you for joining us here today.